Welcome to Hilary Topper on Air, the podcast you can't afford to miss.
Have you ever been concerned about an aging parent who seems to be making bad decisions? Or have you thought about who will look after your children should something tragic happen to you? I'm Hilary Topper, and this is Hilary Topper on Air. Today, I'm really excited. I'm speaking with Eric Einhart, who is a partner of the Russo Law Group PC. That's Long Island's signature elder law, special needs, and estate planning firm. So, Eric, tell us a little bit about yourself and the Russo Law Group.
Well, thanks for having me on, Hilary. I appreciate it. As you mentioned, my name is Eric. I'm a partner with the Russo Law Group. We are a boutique law firm with offices in Garden City, Lido Beach, Islandia, Bayshore, and Manhattan, New York. And we help families. We help families handling estate planning, elder law, and special needs planning. My practice in particular focuses on the areas of elder law, special needs, and estate planning. I also handle trust and estate administration, guardianship, and real estate law. And a lot of our practice really revolves around focusing in on families and particular issues that they may be having with regard to estate planning and, as you mentioned, guardianship and issues of capacity and making decisions for an aging parent or an individual with limited capacity is a big part of that.
So, as we said, today's topic is guardianships, and I'd like you to explain to me what exactly a guardianship is.
Well, a guardianship is a court proceeding to appoint an individual known as a guardian to handle the personal needs and or property management of an individual who either lacks capacity or has functional limitations.
So, what is a guardianship proceeding?
Well, a guardianship proceeding is a court proceeding to appoint an individual known as a guardian to handle the personal needs and or property management of an individual who either lacks capacity legally or who has functional limitations that would cause them to have the need for someone to help them manage their property management or personal needs.
So what kind of guardianships exist in New York State?
Well, in New York State, there's essentially three types of guardianships. One is a Surrogates Court Procedure Act, Article 17, and this is a proceeding that's brought in the Surrogates Court, and it's for minors, for infants. This is anybody under the age of 18, and this usually comes up when an individual does not have a legal guardian, and someone needs to be appointed to either manage their property or their personal needs. Sometimes you'll see people who draft wills, parents who draft wills, list who they want to be appointed as a guardian in their will. However, if this is not referenced or if the minor inherits property that needs someone to legally be able to manage, you'll have to go into the Surrogates Court and petition to have a guardian appointed for a minor. There's another guardianship proceeding is Article 17A under the Surrogates Court Procedure Act. And this is for adults with developmental and or intellectual disabilities or traumatic brain injuries. And this is for an adult who really has never had capacity and now is over the age of 18 and needs assistance with either managing their personal needs or property management. And the third type of guardianship is Mental Hygiene Law, Article 81 guardianship, and this is for adults with functional limitations. Now, this is not necessarily an all or nothing kind of proceeding. They may have some functional capacity and some lack of functional capacity. And in this case, the court can appoint a guardian for the personal needs or property management in the least restrictive means to help the individual manage their personal needs or property management.
So when you're talking about functional limitations, what exactly does that mean? Is that somebody who has dementia or is at the start of dementia or at the later? Is there a distinguishing factor as to how to determine that?
So it could be someone with dementia or the beginning stages of dementia. It's the Article 17A is for individuals with developmental disabilities and or intellectual disabilities, and this is based on medical evidence, but the Article 81 is for adults with functional limitations, and it's really based on those functional limitations. And if they cannot understand the nature and extent of their limitations, then the court could determine that they lack capacity and need a guardian. So it very well could be as a result of someone's inability to manage their affairs or inability to understand that they can't manage their affairs.
Interesting. And who would this guardian be for, say, I mean, you know, for the first two, it's pretty much, you would think it would be a family member. Would this also be a family member for the functional limitation of an elderly person?
It could be, yeah. So typically for 17 and 17A guardianships, it's usually a parent or a close relative or an interested party in that individual's life. And this is true for an Article 81 guardianship as well for an adult with functional limitations. In our office, typically we see a situation where the adult does not have the proper resources. They did not execute a durable power of attorney or a healthcare proxy or living will, and the lack of these resources or the lack of sufficient resources that would allow someone else to effectively manage their property and personal needs would cause the need for the guardianship. And it's typically brought by an interested party like a child or a spouse, but it could also be brought by the individual who needs a guardian as well. This is a person that consents to a guardianship, and they're called a person in need of a guardian. So it could be brought on by a family member, and the court could appoint really anyone who's eligible legally to be a guardian. You have to be over the age of 18. You cannot suffer from lack of capacity yourself, and you have to be a person that's in good standing with, you don't have a criminal background, and you are, the court is comfortable with appointing you. Oftentimes it is a family member, but it could be a local attorney or a social worker, someone who's done the required training and is listed on the Office of Court Administration list that the court pulls from.
That's so interesting. So what exactly does the guardian do?
Well, it depends on the proceeding and the powers that the court authorizes. So generally, personal needs guardian, so a person who's appointed as guardian to care for the personal decisions of the individual, can make decisions with regard to the living arrangements, the educational and training opportunities of the incapacitated person, can make decisions about medical and dental decisions, end-of-life care decisions. They could also handle the social surroundings of the individual as well, and change their abode. But then you have property management powers that the court could appoint, and this guardian that has powers to manage the property of the individual can make a broad range of financial decisions on behalf of the incapacitated person, such as banking. They can file and pay taxes. They can sell real estate, purchase real estate, pay bills, engage professionals such as accountants, attorneys, social workers, handle Medicaid and estate planning, and apply for government benefits. It really depends on the authority that the court grants to the guardian. And it could be limited in scope or very broad, depending on the court's discretion.
So what's the difference between a power of attorney and a guardianship?
That's a good question. So the power of attorney is a private agreement that the principal has with the agent, and it gives the agent authority to handle the financial affairs of the principal, and that could be broad and comprehensive as well. And as long as it's a durable power of attorney, it extends beyond the capacity of the principal. So a big difference is that the principal is kind of in charge of making the decision, and a guardianship, a court is in charge of making the decision of what authorities to give the guardian. A power of attorney can be revoked by the principal, so long as the principal has capacity. And the guardianship, the judge is, the court really is the only entity that can revoke a guardianship or terminate a guardianship. So it's in our office, we always urge clients or potential clients to execute a durable power of attorney while they have capacity, and to make sure that their wishes are honored, and the people that they would like to make decisions for them if they lack capacity is listed in that power of attorney, rather than leave it to a court proceeding.
All right, before we move on, I just want to take a moment out and say that I am so appreciative of our sponsors and must thank them. Please support our sponsors and tell them that you heard about them on Hilary Topper on Air. Special thanks to the Russo Law Group, MetPro, and Fortunoff Fine Jewelry. So, Eric, back to you. We're talking about guardianships. What's the actual process for a guardian to be appointed?
Well, again, the process for a guardian, it depends on the type of guardianship that you're seeking. So if it's a mental hygiene law Article 81 guardianship for an individual with functional limitations, the process is, number one, there needs to be a petitioner. The petitioner needs to file a petition with the court that indicates the reasons for the need for the guardian, has to list the interested parties that to the court proceedings, such as the next of kin of the individual who's referred to as the alleged incapacitated person, the AIP. So they have to list the next of kin for the AIP. They have to list the reasons why the guardianship is necessary. They need to list the resources available to the AIP, or the known resources available to the AIP, such as an existing power of attorney, an existing health care proxy, living will, last will and testament, or trust document that may be in existence, or if not, list the fact that it is not. They need to list the assets of the AIP, or the income, and any known debts and liabilities. They also need to indicate the powers that they're pursuing, or asking the court to grant the guardian, and they often will name the proposed guardian. Usually we see that petitioners will propose themselves or another family member or a trusted friend of the AIP in the petition, but sometimes they don't want to be the guardian themselves, or they don't know anybody who's best served in that role. And in that case, the court will use its discretion to appoint somebody that it is aware of and feels is appropriate. Once a petition is filed, the court will issue what's known as an order to show cause. And this document essentially provides pertinent information to the AIP about the proceeding, in big, bold print saying, essentially warning, this is a proceeding that is potentially going to take civil rights away from you. These are the powers that the petitioner is requesting. This is a hearing date that in which we will hear the case. The court will also appoint what's known as a court evaluator, which this is an individual that is essentially working for the judge and is the eyes and ears of the court, and goes out into the community and investigates the circumstances, and interviews the AIP, interviews the petitioner, talks to family members of the AIP, and reports back to the court in a written report and in testimony about the circumstances, and provides suggestion to the judge. And the judge can either take the suggestion or not. And it's really a way for the court, the judge, to get a bird's eye view of the circumstance from an independent third party in order to base their decision, as well as the testimony at the hearing. The order to show cause also lists the date of the hearing and information to the AIP. If they want to get an attorney, they can get their own attorney, or the court can appoint an attorney in this order to show cause. Once the order to show cause is served personally on the AIP, and served either via mail or another way that the court authorizes on the interested parties, then you have jurisdiction over the case, and you go to a hearing. And at the hearing, the petitioner has the burden of proving that the AIP needs a guardian, and has to provide testimony and witnesses that can testify as to the functional limitations of the AIP. And presuming they're successful, or unless there's a settlement and the guardianship is on consent, the court will issue an order and judgment and either make a determination of the capacity and who will be appointed as the guardian. So it's a process. It's an onerous process. It could be time-consuming and costly, both financially and emotionally to the family. And we always try to guide our clients to, when you have the opportunity, execute those advanced directives, those durable power of attorney, the healthcare proxy, the living will, while you can, to hopefully avoid the need for this.
So what are the costs involved in this?
Well, it depends on if the proceeding is contested, either by the alleged incapacitated person or by other interested parties like family members. It could get very expensive. I mean, you have to pay legal fees, both the petitioner and if the alleged incapacitated person has their own attorney or any interested parties, they pay legal fees. You could pay them either privately or have them be court awarded. There's court fees, and there's court appointee fees. So, for instance, the court evaluator gets paid either from the alleged incapacitated person's assets, or if the case is not successful, or the judge determines that the petitioner needs to pay for the fees, the petitioner could pay for the fees potentially. There's also court-appointed counsel. So if the judge determines that this alleged incapacitated person needs their own attorney and they want to make sure that they have an attorney, they can appoint an attorney for that person, and then that person needs to get paid.
Wow.
If the court appoints a guardian, then the guardian could get paid as well. A lot of times we see family members who act as guardians, they waive their right to a commission or they may waive their right to compensation, but that's not always the case. And if it's a professional, they will likely take fees as a guardian. And they should, because they're doing a job, and it's a tough job to do.
Absolutely. So tell me, how can the Russo Law Group help here?
We can help in a number of ways. The ideal way to help, it would be to avoid the need for a guardianship, and that would be to plan ahead. That would be to meet with clients and discuss, their wishes with regard to their financial management and healthcare management, and who best could fill the role of a healthcare proxy or a power of attorney. And advise them on that, draft the documents, and oversee the execution and make sure that their wishes are honored. That would be an ideal situation. But we live in the real world, and those situations don't always come up, and you could have situations where they have a power of attorney that was drafted but not drafted and executed properly, and now the document is either invalid or insufficient, or the person never got to the point where they were able to sign a power of attorney or a healthcare proxy, or they just failed to do so for whatever reason, and then they need a guardianship. And we represent petitioners in guardianship proceedings. We represent alleged incapacitated persons defending or consenting to a guardianship. We also can represent interested parties, which could be the spouse of an alleged incapacitated person, or a child, or a sibling of an alleged incapacitated person, just to make sure that their rights are protected. And we also represent guardians. A lot of times we'll help guardians prepare annual accountings, because once they're appointed, their job isn't over. They have to go back to the court annually and provide accounting of the assets and make sure that the individual is in good care. We also help when the guardianship is terminated, whether it's the incapacitated person passes away or they want to be discharged as a guardian, we help with that. And another big part of the way that we help guardians is we help do Medicaid planning. So a lot of times the need for Medicaid planning coincides with the loss of capacity, and there needs to be a guardian that gets appointed, and the guardian at that point needs to manage the assets in a way that would help the incapacitated person qualify for means-based government programs like Medicaid. And we assist with the planning, and we will go to the court and explain the best way to do Medicaid planning in this given situation, and help the guardian get the alleged incapacitated person or their ward on Medicaid.
Okay, so how can people get in touch with you and learn about the Russo Law Group?
Well, we can be reached at 516-683-1717. We can also be reached via our website at www.vjrussolaw.com. I'm happy to answer emails and have consultations with individuals at any one of our office locations, or you can come to one of our seminars. We have many different seminars each month, and our website has a list of seminars and calendars, and you can always sign up for our blog posts where we provide information regularly.
Thank you. So I was talking with Eric Einhart. He is the partner of the Russo Law Group, Long Island Signature Elder Law, Special Needs, and Estate Planning Law. And you could reach them at www.vjrussolaw.com. Thank you, Eric, so much for being on the show. And I also want to thank our sponsors, the Russo Law Group, MedPro, and Fortunate Fine Jewelry. And last but not least, I want to thank you, our listeners, for tuning in. If you want more information on this show or any other show, you can visit our website at hilarytopperonair.com, or you can find us on Spotify, iTunes, Google Play, SoundCloud, you name it, we're out there. We hope you have a great week, and we'll see you next time. Okay.